and managing PohWer's community advocacy, PohWer's advocacy services. And PohWer is part of a partnership in Lambeth. So we provide the services with different partners. So we're just here to, these are all the different partners of the partnership. And the different advocacy services we're providing is the independent mental health advocacy, which is provided by Community Support Network, advocacy under the CARE Act provided by Dazzle, and PohWer is providing the NHS complaints advocacy, the IMCA service, the RPPR service, and the 1.2 representative service. And we're just going to explain about the different services we're doing, obviously, because they all have to do with the Mental Capacity Act, and we're all working in line with the Mental Capacity Act. And I'm handing over to Catherine. Just introduce her and start.
Hi, my name's Catherine. I work on Anna's team in Lambeth, and I'm an independent advocate with PohWer. Just some quick quiz questions for you. I don't know if people want to just put a T or an F in the chat box if possible, just to indicate what we think. So first question, the Mental Capacity Act 2005 only applies to people in hospitals and care homes. What do we think, true or false? Any ideas? Yeah, we've got a false. Another false. Excellent, good stuff. Yeah, fabulous. Okay, yeah, so it's false. So the Mental Capacity Act applies to all other settings. It can be supported housing, people in the community. So the Mental Capacity Act is there for everyone involved in care, support and treatment of people over the age of 16. So next one, making an unwise decision indicates a person lacks capacity to make that particular decision. What do we think on this one? A true or false on this one? Excellent, lots of false again. Yeah, absolutely right, it's false. Principle 3 of the Mental Capacity Act does state that people should not be treated as lacking capacity just because they appear to be making an unwise decision. Fabulous. Next one, the Mental Capacity Act 2005 requires that regard must be had to whether there is a less restrictive option. But where are we with this one? What do we think? True or false? Does it require that regard must be had to whether there is a less restrictive option? Oh. So yes, it does, it's true. So principle 5 of the Mental Capacity Act does state that regard should be made before the act is done or the decision is made. Regard should be made for whether it can be effectively achieved in a less restrictive way. And last one, if a person who lacks capacity for a particular decision has family, they are not entitled to an IMCA. Is that true or false? Got some trues, quite a lot of trues there. Interesting. Yeah, we've got a false. Okay, that's interesting. Yeah, brilliant. Sometimes true, sometimes false. Yeah, brilliant. So yeah, absolutely. The answer is that if somebody does have family, they can still be entitled to an IMCA. So when we're looking at supporting somebody with safeguarding issues, it may not be appropriate to consult the family or other issues. It can be a decision by decision basis. It might not always be that somebody has someone who is able to support them appropriately in an issue. So that person might still be made aware of what's happening. They might just not be appropriate to consult or to support.
Catherine, I think you've muted yourself.
I know. If we can move on to the next slide. So principles of the Mental Capacity Act. We've got another little quiz here. Don't know. Can we? Yeah. Okay. So which of the statements below are principles of the Mental Capacity Act 2005? So
your slide deck hasn't moved.
Oh, I've moved it along, but I don't.
Has it not? Because I have it here, so you can't see
Yeah.
it.
What number are you on?
I'm on number 5, sorry.
Okay, we're currently on number 4.
I've moved it along.
Mine is on number 5, but it says that there's someone else having control of this now, so I'm not sure what happened.
No one.
Shall I?
Control. Do you want to start again, Anna? Start your slideshow again.
Let me just try and take control again. Okay, can you see this now?
Yes.
Okay, great.
Perfect.
Yeah, you all good?
Yeah.
Excellent. Okay, thanks, Anna. So, principles of the Mental Capacity Act. So, which of these statements below are one of the 5 principles of the Mental Capacity Act 2005? So, do we want to put hands up? Anyone who wants to tell me which one of these are one of the 5? The easiest way to do it? He's going to give me the first one. Yeah, so we've got the first one there, presumption of capacity. Yeah, a person must be assumed to have capacity unless it's established that they lack capacity. Fantastic. Yeah, number 1. 4 more we need. Number 2, yeah, so we've got a person is not to be treated as unable to make a decision merely because he makes an unwise decision. Fantastic. 3 more to go. Right, we've got number 7. Number 7 is actually one of the fakes. So number 7, every effort should be made to encourage and enable the person who lacks capacity to take part in the decision-making process. So that's actually part of the best interest checklist. Number 4, yeah, perfect. Person must be assumed to have capacity unless it is established they lack capacity. Yeah, number 8, perfect. An act done or decisions made under this act for on behalf of a person who lacks capacity must be done or made in his best interests. Number 6, perfect. Yeah. So number 6, a person is not to be treated as unable to make a decision unless all practical steps to help him to do so have been taken without success. I think we've got 1 more to go, haven't we? Any takers for the last one? So last one, number 3, is before the act is done or a decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of the person's rights and freedom of action. Fantastic. So that's the 5 principles of the Mental Capacity Act, and then we had 3 fakes in there. Thank you.
Right, so thank you everyone for participating in this, and yeah, for just checking how much we hopefully know about the MCA and the principles. We're coming now to the different roles we're providing, obviously, that are in line with the MCA. And the first one and the main role we are doing in Lambeth is the IMCA role, so the Independent Mental Capacity Advocate. And an IMCA would always, when we receive a referral, check who's the decision maker. So if you do make a referral to us, it's really important that you include the decision maker's details in there so we can contact them. We obviously support and represent the relevant person, so the person the decision is to be made about. We're not there to give our own views and opinions. We meet with the person in private. We ascertain the person's wishes, feelings, and views as far as that's possible. So we will speak to them. Yes, you are supposed to see the slide number 6. I don't know why this isn't working. Am I not sharing this?
It's not. You're doing fine, Anna. Number 6
Okay,
is showing
good.
on the screen.
Okay, great, good. So obviously, if someone is non-verbal, you know, we may do observations, we follow the rights-based approach, we do the watching brief, you know, we speak to relevant professionals, we look at records, we try and gain as much information as we possibly can. We also examine and take copies of relevant health and social care records. We obviously try and do as much paperless as we possibly can, so we might ask for copies to be sent to us. We ascertain whether alternative courses of actions have been considered. We may have to obtain a further medical opinion if it's regarding a serious medical treatment. IMCAs will challenge decision makers, and we also can submit a complaint on behalf of that individual if needed. So an IMCA is not involved when the Court of Protection has appointed a deputy who continues to act on the person's behalf. If the person who lacks capacity has appointed an attorney, the person has capacity. The client's accommodation is regulated by the Mental Health Act, because then they might be entitled to an IMHA. The treatment is regulated by Part 4 of the Mental Health Act.
Hello,
and
Tracy speaking.
Can you mute yourself, please,
Hi,
Tracy?
Hi, thank you. I appreciate you calling me.
Tracy, can you mute yourself, please?
Okay, sorry. And the treatment is urgent, or the treatment or move are urgent, because then the best interest decision can be made without IMCA involvement. And IMCA does not assess the client's capacity, so we only get involved once it's established that the client lacks issue-specific capacity. We don't make a best interest decision. Obviously, we represent the person during the best interest decision process, and we don't mediate between family and professionals. So it might be that the family has got different views than the professional, but that doesn't necessarily mean the person is entitled to an IMCA if the family is still acting in that person's best interest. And there is a legal duty to instruct an IMCA when there's either decision to be made regarding a serious medical treatment or change of accommodation. So then you have to instruct an IMCA if the person has been deemed not to have time and issue-specific capacity, and the person has no close family or friends who are appropriate or practical to consult with. And it can be that there is family or friend, but maybe they don't even want to get involved in that decision. We kind of have that quite often, where they say, I'm happy to be there, but I don't want to have anything to do with that decision. So in these two instances, you have to instruct for an IMCA.
So one of the instances where you must instruct for an IMCA is for a change of accommodation. So it's a long-term change of accommodation decision, which could be if there's a planned admission to hospital for 28 days or over, or if it's 8 weeks or more in any other accommodation. The restriction for IMCA involvement eligibility is that it must be arranged by the NHS or local authority, the accommodation. There are exemptions around the Mental Health Act. If the person is being moved under the Mental Health Act, they wouldn't necessarily be eligible for IMCA support, but to bear in mind then that they are likely to still be eligible for IMHA support at that time. Anyone who's in receipt of Section 117 aftercare, who's been discharged from the Mental Health Act, they are entitled to an IMCA for support for a change of accommodation. They're moving away from the Mental Health Act, they're moving under the Mental Capacity Act that way, so they would be entitled to IMCA support at that time for the change of accommodation.
Right, so the next part where you have to instruct an IMCA is a serious medical treatment, and that's defined as the following. So giving new treatment or stopping a treatment that has already started, or withholding a treatment that could be offered in circumstances where, if a single treatment is proposed, there's a fine balance between the likely benefits and burdens to the patient and the risks involved. A decision between a choice of treatment is finely balanced, or what is proposed is likely to have serious consequences for the patient. And that really can depend on that specific treatment, depends on the person's circumstances. So quite often we, for example, get serious medical treatments around dental treatments for people with learning disability, because they may have to be sedated in order to receive that treatment, but might not be actually regarded as serious medical treatment for someone else. And ultimately, it's up to the decision maker to say what constitutes a serious medical treatment. And we will always have that this discussion with that decision maker before we start our involvement. IMCAs can be instructed for care reviews, but that's only accommodation reviews where the accommodation is or will be longer than 12 weeks. There's significant changes to the care plan, and again, no friends or family to consult, and the client obviously has been assessed to lack capacity. Any reviews of the care and support plans come under the Care Act, so that would be Section 27 under the Care Act, and you have to instruct for care advocate if that person meets that eligibility criteria. You can also instruct IMCAs for safeguarding adults cases when abuse must have taken place or is suspected, but there have to be protective measures proposed or undertaken, so we can't get involved if there are no proposed protective measures. Again, the person would have to have been assessed to lack capacity to consent to these proposed protective measures. There has to be a clear benefit to the client for having an IMCA involved, and IMCAs can be instructed for the victim or the person suspected to have caused harm. And that's regardless of family or friends' involvement. And especially you might want to consider instructing an IMCA if there is a conflict of views between family professionals, or the client strongly indicates that their views are not being taken into consideration by the decision maker. But again, we have to have the proposed protective measures. It might be more appropriate in most safeguarding adults inquiries to instruct for advocacy under the Care Act, because the care advocate can support the client from the very beginning of the inquiry. The IMCAs normally only get involved at the end when there is an outcome proposed protective measures. Astrid, to you.
So quick quiz just to see what you've remembered from what's been said in the last few slides. So just a quick quiz about what the IMCA role is or isn't. So should we do T and an F in the chat box again, just to see? IMCAs never work with people who are befriended. Oh, I think we've got a question to go back to there. Should we go back to that? There was a question there, I think, from Emma.
Do you want to, I don't want to stop sharing in case I'm losing this again. Do you want to read it out?
It's disappeared.
Oh.
Jenny, are you able to see there was a question popped up from Emma?
Yeah. Okay. Emma is saying that I understand that the Care Act removed the safeguarding IMCA role. That is what the draft MCA Code of Practice says.
No, we're still getting IMCA referrals for safeguarding if they're proposed protective measures. Quite often it might be something around a change of accommodation if someone, you know, maybe has faced abuse at their own home, and then a consideration is made to remove them from the home. It could be instances of neglect. So we still get involved with proposed protective measures, but it is more appropriate to actually instruct advocate under the Care Act, because they can support the clients throughout the whole inquiry rather than just at the end what the IMCA would do.
Is that okay? Does that answer the question? Sorry. Okay. Yeah. Okay to move on. Okay. Oh, fab. Yeah. Brilliant. Thanks, Emma. So yeah, IMCAs never work with people who are befriended. I think the majority of the answers there were a false. Yeah, absolutely right. We can work with people who are befriended, particularly as we've just been talking about safeguarding cases. It's often just not appropriate to have the client perhaps supported by people they're befriended by. Number 2, IMCAs can speak to the family of the client. True or false? Fantastic. Yeah, true. Yeah, absolutely true. So if we're trying to find out all about our client, about the person, then speaking to the family of a client is often one of the best sources of information that we have. It's where it's appropriate, though. Obviously, we wouldn't speak to a member of the family if they were deemed to be the perpetrator in a safeguarding case. If our client has specifically said to us ourselves that they really don't want us to speak to family about an issue, we will roll with that. Obviously, we take our lead from the client. IMCAs carry out the capacity assessments. Is that part of our role? True or false? Yeah. Brilliant. False. Yeah. IMCAs don't carry out the capacity assessments. We will read through them and we have a good look through them, and we will obviously take on board what the capacity assessment says. Leading into the next one, can an IMCA challenge that capacity assessment? True or false? Yeah, we've got quite a lot of false, some trues, bit of a mixture. Yeah, it is true. So as an IMCA, if we have a concern over a capacity assessment, very often it's after meeting with the person ourselves. If we're then looking at the capacity assessment we've received and then reflecting on the evidence we've collected from meeting the person, we can challenge capacity assessments and say that we feel perhaps that might need to be redone. Quite often, if a capacity assessment has been completed a while ago, and the person seems to have regained some capacity, the situation may have changed, we will challenge those assessments and ask that perhaps they be recompleted. And the last one, IMCAs can only represent a client on one issue at a time. Is that true or false? Yeah. False. Brilliant. Fantastic. So yeah, it's false. We can represent the client on more than one issue at a time. However, there is a caveat to that. We would need to know that there has been a mental capacity assessment completed for each specific decision, and we will need to know who the decision maker is for each specific decision also. So we often get referrals that have a couple of different issues on there. But yeah, as Emma says, each issue has to be a different decision with its own decision maker specified, and an MCA completed in a timely fashion for each one as well. Thank you.
Great, thanks for that. So that leads over to the role of the decision maker. So decision maker is obviously depending on what kind of decision it is. Catherine is going to explain a bit more who can be a decision maker. But prior to instructing for an IMCA, the decision maker must deem the person to lack capacity following appropriate assessments. And as we've just said, we can challenge capacity assessments. They need to deem the client to have no appropriate person to consult with and to inform any family or friends who are actually involved but not appropriate or practical to consult with why that is the case, and that they have made a referral for an IMCA or will make a referral for an IMCA. They have to include the client in the decision-making process, obviously, adhering to the best interest checklist and the principles of the MCA.
Thanks, Anna. So who can be the decision maker? Well, that differs for different decisions. For serious medical treatment, we would expect the decision maker to be from the NHS body that's carrying out the treatment or the procedure. So the referrals that we receive, for example, if it's for dental treatment, it's likely to be a dentist or somebody from a specialist care dental clinic. For surgery treatments, it would usually be the surgeon who's likely to be carrying out the treatment. Referrals can come from somebody else, so quite often we receive referrals and it will be somebody under that surgeon's team who's completed the referral document, but we must have that decision maker recorded on the referral. For a change of accommodation in hospital, it would usually come from the decision maker would normally be somebody from the NHS body, so a care coordinator often. And then for a long-term accommodation change over 8 weeks, it can be an NHS from someone from the NHS body or the local authority, so social worker or a care coordinator very often. For safeguarding adults, IMCA referrals, it would be someone from the NHS or the local authority. And again, for accommodation reviews, that can be someone from the NHS or the local authority. Deprivation of liberty safeguards, the decision maker will be the supervisory body on that one.
Yeah, so speaking about the deprivation of liberty safeguards, so they only apply to hospitals and care homes at the moment, and deprivation in other places such as supported living or the community currently have to be authorised via the Code of Protection. That is going to change with the LPS whenever they may start. And obviously, in order for someone to be deprived of their liberty, they have to meet the acid test. So that means that staff at that place, care home or hospital, have to have complete control over that person, so that that person is under continuous supervision and control, and they're not free to leave to live elsewhere. And that's the important thing. So we have clients who are deprived of their liberty and under adults, but they can still go out in the community by themselves, but there are measures in place that if they don't come back at an agreed time, you know, the police might be called and they will be taken back to the care home or the hospital, so they're not actually free to leave and live elsewhere. Obviously, the person has to be assessed to lack capacity with regards to care and treatment residence, and it must be in their best interest to be deprived of their liberty, protect them from harm or likelihood of harm occurring. And there's certain assessments and criteria that have to be met. So the no refusals, the age, mental health and eligibility assessment.
So IMCA referrals under the deprivation of liberty safeguards, we have three strands here. So we receive referrals for 39A IMCA support. So in this case, we are being referred to as an application for a deprivation of liberty has been made. And our role as an IMCA here is to look at whether the proposed DOL, the deprivation of liberty, is in the person's best interests. Do the restrictions appear to be proportionate? Do they meet, does the restrictions meet the principles of the MCA? Does the proposed DOL meet the principles of the MCA, those 5 principles that we've looked through? And has consideration been made to meeting the best interest checklist? So the best interest checklist, there's a long list under Principle 4 of the Mental Capacity Act. So the deprivation of liberty must make reference to that checklist. We also receive referrals under for 39C support, IMCA support. So this would be an IMCA providing support where a person has a family member or a friend who's willing to be their relevant person's representative, but perhaps there's a period between them agreeing to take that position up, or they may be on a long-term break, they may be unwell in hospital, on holiday. We can be instructed to cover that period for while the relevant person's representative is not available. And we also can be instructed under as a 39D IMCA for support, and that's support to the relevant person or the RPR or both. And the role there is to help either the relevant person's representative or the relevant person himself to understand what the deprivation of liberty means. And a lot of the time it's about explaining to a relative or a family member what the process is for supporting the relevant person through a review of that deprivation of liberty, or what they need to do if the person's objecting to their placement, and they need to apply to the Court of Protection to challenge that deprivation of liberty. So that 39D role is often, it's generally phone calls to the relevant person's representative. It's explaining, looking through documents with them, and talking through processes of what they must do as part of the role of relevant person's representative.
Okay, for someone who doesn't have family or friends who can represent them while they're deprived of their liberty, because there's a statutory right to have a representative. If someone is subject to standard authorization of adults, then a paid representative has to be instructed by the supervisory body, and they're supporting for the whole duration of the authorization. So our RPPRs, we visit the clients every other month at the moment, unless there's some kind of issues we might need to follow up and visit more often. We will ensure that the conditions of the standard authorization are being met, and we comment on this. We complete a report where we will always comment on that, whether they're met or not. We can support the person to call for review of the deprivation of liberty, or we can support someone to access the court if necessary and support them with Section 21A appeal. So that means challenging the deprivation of liberty at the Court of Protection. We normally then instruct a solicitor and, support the client through the whole court proceedings. We might meet with the client and the solicitor. We, again, share our reports with the solicitor, so they might be part of the court bundles. And we can also meet with the client and the judge if that's needed. And what we do in London is that for someone who is deprived of their liberty and has an RPPR, and there's a proposed change of accommodation, the RPPR can support that person with the change of accommodation. So there's no need to make an IMCA referral, because the RPPR will be there to support with that decision, and because the client would be regarded as befriended because they have the RPPR. We can't support with any placement reviews, serious medical treatment, or safeguarding issues. So that would require IMCA instruction if that was needed, and the person would obviously meet the eligibility criteria. And in Lambeth, we also provide the Rule 1.2 representative service. So that is an advocate who supports someone who is deprived of their liberty in the community. So where the deprivation of liberty has been authorized through the Court of Protection. And we do that when social services are planning to make an application to the Court of Protection to ask for deprivation of liberty in the community. So we meet the client, we ask for the care and support plans, we complete a COP24. And then once the court has authorized the community deprivation of liberty and instructs us as the Rule 1.2 rep, then we continue to visit the client regularly. Again, it's every other month. And, we provide reports, we flag any issues that are there, and, regularly meet with the client and make sure that their views and wishes are listened to. Just in case anyone wants to contact us via Connect Lambeth. And yes, if anyone has any questions, we will try our best to answer them. Or anyone else wants to share anything or ask anything, please feel free.
Okay, Emma had popped in the chat that the current thinking is LPS will not be enacted, at least not the current version. So we should push ahead with the community DOLS applications.
Yeah.
Just to share that with you. Thank you, Emma. Go on, does anybody have any questions? Don't be shy. There's 66 people on the call. Smita.
Hi, I'm Smita. I'm home manager of Ashna House in Streatham. Actually, I want to clarify one thing. I have residents from different local authorities, and if I want to apply directly myself, refer my residents to IMCA because they are living in Lambeth. So is it true? Yeah, I can. Because they are from different, their funding is from different local authority.
So can I just ask, why would you need to refer for an IMCA? Is it for around a serious medical treatment or?
No, I can be, at the moment, I don't have any case to refer to IMCA, but I'm just giving you one example. Like one of my residents in past, she want to go to India for permanently, move to India. And she was from different local authority, her placement and her funding. So I think we made a referral as well directly to Lambeth IMCA.
So for IMCAs, it's where the body lies, so where the client is, that's your IMCA provider. So anyone who is in Lambeth and needs an IMCA will obviously be supported by our IMCA service because it's where the body lies. With the RPPR cases, it depends on the supervisory body. So we are commissioned to provide RPPR service to anyone who is deprived by Lambeth, but they can be placed in all of the London boroughs. So we don't need to have them only living in Lambeth, if that makes sense. But if you do make an IMCA referral, we always would need to know who the decision maker is. So, you know, you can make a referral, but we might come back to you and ask you who's actually the decision maker, who's, you know, responsible for that decision.
Yeah, it was a supervisor, like it was actually even Doll's application, and it was supervisory body was a different borough, and they were the decision maker about that. So
yeah, so if you're requesting standard authorization of adults, and let's say that person is funded by Brent, you would obviously request that via Brent, and then whoever is the RPPR provider for Brent, they would provide your RPPR, but the 39A IMCA, because the client is in Lambeth, would be asked because we're doing the IMCA service in Lambeth. If that makes sense. I hope that makes sense.
Yeah. Thank you. Because I have so many different residents from different local authority and funded by them. So I want to just make it clear, more clear about.
Yeah,
that.
but we're
So
always
thank
happy. You know, Connect Lambeth, we're always happy to take any questions and answer any questions if we do have and signpost appropriately.
Yeah, thank you so much. Thank you.
James from the Carers Hub has popped in, some info in the chat. If an RPR has been agreed due to lack of capacity, can a social worker meet with the client without the RPPR and make a decision they have capacity, but still instruct a RPR for future meetings?
So the RPPR is supporting someone when they're deprived of their liberty, and that role is limited to that deprivation of liberty. So when we go in and meet with that person every other month, we're speaking to them, explaining to them the DOLS process, what that means to them and what their rights are. So if a social worker meets with them, we don't need to be present at that meeting unless, you know, it might be around a change of accommodation, then we can obviously support with that as an RPPR. But again, you know, if the social worker does a capacity assessment, that has to be for a specific decision. So we wouldn't need to be in that, and we wouldn't be sitting in capacity assessments. Anyway, neither is an IMCA or an RPPR.
Thank you.
I don't know if that answers the question though.
Let us know, James. Yeah, that's fine. Thank you. Any more questions? Right. Okay, if there's no more questions, was that your final slide, Anna?
Yes, that's the final slide.
Thank you for this afternoon's interesting session and for the great interaction. It was very good. That's what we just needed on this last session for MCA week on a Friday afternoon. So thank you. And
thank you for inviting us.
You're welcome.
Thanks very much, Jenny.
You're welcome. Thank you very much for joining us. And if you're okay with that, I'd like to share the slides afterwards with for people that have not been able to attend today.
Yeah.
Great. Perfect. Thank you. Right. Thank you all for coming today. And you'll get back 20 minutes for your lunchtime. Thank you.
Okay.
Thank you very much.
Bye.
Thank you. Bye-bye.
Thank you.
Thank you. Thanks. Bye.